This has been a crazy week in the courts. First week back with the Supremes, all this craziness with the TROs and the indictments, but this isn't nearly as scary once you understand what's really happening. So, before you call it Pauhana for the long weekend, let's catch up one last time. Happy Friday, everybody. I'm Bryno, and this is the Aloha Friday Morning Report on the federal courts for October 10th, 2025. Please, double tap your screen. Comment how you plan to spend your extra day this weekend, and stick around through the intro. It gets me through the FYP faster. Grab yourself a coffee or a coffee colada, and let's end this week right, shall we? Again, I know this news is a little intense, but I think you'll have a more relaxed weekend if all of this is contextualized a little. That said, we are going to start by jumping into the deep end. New York Attorney General Letitia James was indicted yesterday on 2 counts related to mortgage fraud. Now, I've looked through the charges and I noticed one big problem. Both of the charges hang on Ms. James making a false statement when she bought a second home in Norfolk, Virginia. Now, I am not a mortgage expert, so I'm just reading what it says in the indictment. So, presuming that everything in the indictment is correct, which, But it sounds like Ms. James needed to decide whether she was buying a vacation home or a rental property. And according to the indictment, choosing vacation home or second home gets you a better rate. I don't know. Let's assume that's true. The allegation is that Ms. James checked vacation home or second home box when she bought the house, but then she rented the house out anyway. Okay, few things here. First, according to the indictment itself, both charges hang on Ms. James' intent at the time she bought the house. The indictment says she checked a box saying her intent was to buy a second home, but later she rented it out. And the indictment says that renting it out later is proof that she intended to rent it out all along. But we've discussed intent a little in the past. It is very hard to prove. And Ms. James, as a smart attorney, she's going to know what to do and say here. The fact that she rented the place out later doesn't prove that she intended to do that all along. So even if the indictment is totally on the level, and I would say this feels very tough to prove, unless she admits it, which I don't think she will. Here's the thing, the government lawyers knew that too. They had to go through a lot of lawyers to find someone who was willing to bring this charge, so the evidence is probably pretty weak. But there's something else you'll notice here. The specific language that Ms. James leveraged this false statement to, quote, obtain favorable mortgage terms is gonna sound pretty familiar, because it's exactly what she convicted Donald Trump of doing. So this is pretty clearly retribution. The difference here is that, like I said, intent is really hard to prove, but she had actual proof when she brought charges against Trump. And people have asked me, how do you prove intent? Well, you use the person's statements. And in the case of Donald Trump, she had actual evidence of him essentially saying, this is what I'm doing and why I'm doing it. I'm oversimplifying, but bear with me. So in general, I don't think you're going to find evidence of your average person saying something like that. Also, your average person isn't going to have a whole team that they discuss these sort of decisions with who you can bring in to give testimony. But the reason that I am so darn sure that there is no evidence of her saying any of this is because if there were, the prosecutors would have brought the charges earlier and Pam Bondi wouldn't have had to start firing people to get them to bring charges. So I don't think this is going anywhere. But the bigger thing is, we talked earlier this week about the Abrego Garcia case and how the federal judge actually made a finding of vindictive prosecution, which is probably going to get some lawyers disbarred. So the lawyers bringing these cases in Virginia, like this one and the one against Comey, going to be in trouble if they keep throwing around prosecutorial discretion like this. But you know what? Not my circus, not my monkeys, not my bar license. So you kids have fun. Okay, we're going to turn to the court's response to the ramp up of federal officers and federal troops. There have been some pretty major developments in both Portland, Oregon and Chicago, so let's catch up. We're going to start in Portland, where a very confusing order from the Ninth Circuit in City of Portland and State of Oregon v. Trump had me reading in circles for a bit, but I think I finally got it, so let me break this down. Okay, so Pete Hegseth issued a memo that federalized the Oregon National Guard and deployed them. That's memo number 1. And federalizing basically means they now answer to the president instead of the governor of Oregon. But then a district court in Oregon enjoined memo number 1. So Hegseth was stopped from federalizing or deploying the Oregon National Guard. Got that? Okay. Then Hegseth wrote a second memo to add some more troops, just in case the first one got gunked up. So he sent troops from California, who were already federalized under another order, to Oregon. And so the district court wrote a second injunction for the second memo, but all it said was the feds cannot deploy any National Guard troops to Oregon, period. Well, the feds appealed and requested a stay until the appeal is decided. And the Ninth Circuit said, we're going to need a few days. But in the meantime, we're going to give you a temporary stay. But we're only going to stay the first injunction, not the second one. And this is why I was so confused. So the First Amendment, or the first memo, is active. The injunction against it is paused. So in theory, the Oregon National Guard is federalized and deployed. But the second injunction, which said no deployments are allowed at all, that one's not stayed, which means neither the Oregon nor the California National Guard can be deployed in Oregon. So the feds are now stuck paying for the Oregon National Guard that they've federalized, but they're not allowed to have them do anything, which is kind of funny. I'm sure we're going to get another update on this soon, so we'll find out about that sometime in a few days. So that's the first thing that happened this week. But the case in Portland also opened up a bit of a Pandora's box for the feds, because meanwhile, Gavin Newsom still had a case pending before the Ninth Circuit over whether or not feds can keep troops in California. And the feds say that the situation in California is so dire, they absolutely have to have troops there to keep federal property and federal agents safe. So Newsom filed a motion with the Ninth Circuit this week and said, if the feds need the military support in California so badly, why are they sending them to Oregon? And if they don't need them, then give them back to us. We want our National Guard back. So that motion is now pending, and we'll see how that plays out. So Ninth Circuit, very busy this week, but if you think things are crazy there, let's head to Chicago, the other war zone that they keep sending federal troops and federal officers to. So there were two major cases, both heard in Chicago yesterday, both with nearly identical case numbers. I've only included one of them in the graphic. That's Chicago Headline Club v. Noem, 25 CV 12173. The other is City of Chicago and State of Illinois v. Trump. That's 25 CV 12174 instead of 73, if you want to look. Both of these cases had temporary restraining orders issued yesterday until the court has time to hear preliminary injunction arguments in about 2 weeks. And both are about the use of force by feds on American citizens. Chicago and Illinois v. Trump, just like Portland and Oregon v. Trump, is about deployment of National Guard troops, but this time in Illinois. Yesterday, a federal judge issued a TRO enjoining the government from federalizing or deploying National Guard troops within the state of Illinois. So, none. But this morning, the feds filed an appeal with the Seventh Circuit. So now, both the Seventh and Ninth Circuits are considering basically the same question. So we'll see how that comes out. Second case, Chicago Headline Club, is about the use of riot control devices by federal officers on people who were exercising their First Amendment rights. And three groups are protected by the TRO that issued yesterday. So the first group are journalists who are documenting things, then people who are practicing their religion, and finally people who are peacefully, and that's key, peacefully protesting. This TRO stops federal agents, which would include ICE, CBP, FBI, I guess, any federal agents from interfering with people who are doing any of those three things. I've talked about this a lot the last couple of days. The judge worked very hard with the parties to make sure that this order was just flexible enough to allow officers to do their jobs without being so strict that, or with being just strict enough so that they couldn't get around it super easily. The TRO also requires all federal officers who are not actively undercover, and this was pretty narrowly defined, to wear visible identification so that they can be identified. As of right now, this one doesn't seem to have been appealed. I was under the impression from the attorney in the hearing that it had already been appealed, but I don't see it on the docket. So for now, I think they're focusing on the other one. I don't know. I mean, most of the requirements of this TRO are essentially that the federal agents just abide by the First and Fourth Amendment. So it's kind of a tough sell to appeal, I think, but you know, there's a lot of technical stuff in there, so I could be missing something. All right, folks, that is your Aloha Friday morning report. We have a long weekend ahead of ourselves. Enjoy it. You have earned it. Go get some apple cider or PSL or something stronger. I will be back on Tuesday with the Supreme Court arguments for next week. Seriously, go enjoy the weekend. We all need it. Mahalo and fa'afatai for watching, everybody. Manuia leaso. Have a fantastic weekend.